Mamuina akwaba de ba Nkasa TV. Ehwe eye NDC scandals abo maimu ha. Case brim Ghana for akoma pan. Even the president Nana Addo Akufo-Addo kura emane comment about that case. The government official one scandal. And ntini Kiseja bin eba bontin ebe kika nsem bi kura tum say the president Nana Addo Akufo-Addo kura cast also sintin Kiseja bin, I'm very disappointed in you. One mama tanfo enyame. But ka case we the case bia e Ghana ha a lot of Ghanaians follow diligently pan for something to happen. And me cry for some time now. Me follow that case we could baby me feel say na one shania this case will go sideways, but case brim eti for akoma pan the 2.37 million euros ambulance scandal. Accra High Court in sense between Dr. Keso ato Forson Richard Japkah versus the Republic now. It's for instance the do. Now finally Supreme Court the ruling be ababeto concerning the $2.37 million ambulance scandal. Now in sense some lawyer Paul Adom Otri kan ye no it's for abem. There were a lot of Ghanaians that were criticizing this lawyer for about in some of the two ability for there's some lawyer Paul Adom Otri edit to no abem. So chema or sitting sa high court every case starts in the high court and say and if a case starts in the high court that's a movie needs a case no unless say an appeal level. That doesn't mean it's in the case is over because that stage is in the preliminary stages and I say the first stage of every case, but in one it goes higher and higher and higher. And the more higher it goes, the more intense the case becomes. It's here for the $2.37 million at all Forson Richard Japkah. Supreme Court akasa. Ntinya sembre no. Yankone kuti sense muntwe mu bramda mu ina ase.
Process so the Chief Justice Gertrude Tukomu na criminal appeal number J13 date sheho 8th August 2024. The Attorney General Godfrey Yabadame versus the state. Appeals document. Supreme Court acknowledging receipt of it. Free the office of the Attorney General. Appeals document case. This is the appeals document on the case involving Dr. Kesil Forson and businessman Richard Japkah. Now, on the 30th of July 2024, and at the Court of Appeal, it delivered a 2-1 split decision in favor of Minority Leader, former Deputy Finance Minister Dr. Kesil Forson and businessman Richard Japkah. Equity of no wrongdoing in the 2.37 million euro ambulance case. Nipa imi file a case of no submission. In that ambulance case, High Court Botugui established a prima facie case. The case noa. My daughter case lato force a close the case. Ni begin Richard Japkah. But now Omadi kind of file an appeal. The Court of Appeal. So still submission of no case in the appeals court to sign review musan so mu boni bi o maye and so mu jina court na yetoto to omano eno na Court of Appeal no court transfer judges miensa court transfer emu mienu agitu mu se eye no kre omo wiwe mu nyina di adanse se submission of no case ni e wo se gina na high court no ye mfonso enti Dr. Kesil Forson and Richard Japkah inform hu kodi the Attorney General Emma Ghana for nyina say case this is not the end of it. Obeko appeal. Na appeal na okono is moving straight to the Supreme Court. No the assembly na down womo. Na wa kire adekodientia ensese the acquittal of Kesil Forson and Richard Japkah ensese the hold the test of time because ruling no awon so akenkan bi no enfonso bebrebe e wo ho. Now, said the beya obeti case na si making kind the appeal document in achero. But said the beya obehunu said the case ni si ko ni si banutino. Me say to me kwase na ma summarize the entire decision of the Court of Appeal. Ye 2-1. The obia kan ye ntia ne omu gina so e rule is submission of no case no enyina. Na Dr. Kesil Forson and Richie Japkah emfa no nkodi. Any statement Attorney General enso edi ahye ne appeals document mo no so kire say Supreme Court nso hwe so na sa appeals court ruling no ono nso yen set no aside. Say de bia be hu say the case no esi eko. Now judge for me ensan omo tena ase e wo the appeal case no so no eye 1 Justice Kwaku T. Akabuafo. 2 Justice Philip Bright Mensah. And 3 Justice Alex Poku Echampo. These were the 3 appeals court judges. Yeah, omo a rule on the submission of no case and the possible and answer the acquittal of Dr. Keselato Forson and Richie Japkah. Judge Nia will declare Justice Kwaku T. Akabuafo. Ninsem now kind in Nina Mabon Tofan or say, based on my analysis and in fidelity to the law, I am of the opinion that the appeals filed by both the first and third appellants should succeed. In the result, I would allow the appeals and the ruling of the trial court dated March 30th, 2023, calling on the first appellant and the third appellant to open their defense in respect of the charges in count 1 and count 5 hereby set aside. Also, the call on the third appellant to open his defense in respect of the charge in count 3 set aside. In their place, an order upholding the submission of no case entered for both the first and third appellant in respect of those 3 counts in the charge sheet is issued. Consequently, both appellants are hereby acquitted and discharged. Reasons no when Justice Philip Bright di nyina na yepe nti meka ni nyina bom na maka baako. Now, they both made ono and Justice Philip Bright Mensah both made some conclusion, including the fact that the prosecution, which is the Attorney General, did not establish a prima facie case against Forson and Richie Japkah, and therefore the High Court erred by upholding the argument of the state. According to Justice Kwaku T. Akabuafo, Justice Philip Bright Mensah, the Attorney General, and to me I established a prima facie case. Say they rejected the case of the Attorney General that Forson issued the letters of credit without the authorization of the then Finance Minister ßrèak, noting that evidence adduced by confessions from both Forson and ßrèak indicate that his boss ßrèak was very much aware of Forson's actions, and that he ßrèak gave Forson the permission to issue those letters of credit. And the judge for me the other kind say Attorney General can say Forson issued those letters of credit without authorization according to Judge Simienu and yes sanity. And according to Omoka Sane say Forson no one can say the dance or court to say and then the two may soon what the sign. Soon as said Tekpeyana or your finance minister or no so Forson friend as a witness no or no so be dear dance or court to say or no and the man Dr. Keselato Forson to me say on issue those letters of credit. And until on J you are said Tekpasam no 2 munu precope. So you cannot come to court and say that Forson acted without authorization. This is according to the 2 judges. Ebi almost say to succeed on the charge that the first accused acted without cause and authorization, the best evidence to establish it was for the prosecution to have invited the substantive minister, Honorable ßrèak, having regard to the evidence. It was done on his blind side. We are of the considered opinion that ßrèak was a material witness whose evidence would have decided the case one way or the other. Failure by the prosecution to invite him to testify that he did not authorize Forson was fatal to the case of the prosecution. For the law is well settled that if there is a vital point in issue and there is one witness whose evidence would settle it one way or the other, that witness is a material witness that ought to be called to